offices are eligible to be held only by registered or eligible voters under the Minnesota Constitution, Article 6, I believe. And yet, if somebody who was not an eligible voter sought to run for office under Section 204B44, I don't think anyone would say that the fact that that's stated as a prohibition on holding office would mean that they have to appear on the ballot.
Can I follow up on that? Because, I mean, that is a little bit of a different situation, though, because the legislature actually felt the need to pass a specific law to say that the secretary had the power to keep, well, not just had the power, was required to keep the people that have felony convictions, et cetera, incompetent, deemed incompetent off the ballot, which is a little bit different, it seems to me, because there's actually, I mean, I don't know why the legislature felt the need to actually pass a specific law to give him that power if he already had, or the secretary that power, if the secretary already had that power.
Well, if I may zoom out a little bit, I mean, Section 207A.12a says that except as otherwise provided by law, the presidential nomination primary must be conducted the same as any other state primary. And 204B44A1 talks about any candidate on any official ballot, and it specifically includes
to come back to the timing question, though, which is troubling me too. Is the word eligible in 204B44, is eligibility determined at the time of placing on the ballot, or is it determined at the time of taking office? What is eligibility? What is it referring to?
Well, if I may answer that in two ways. One, with respect to 204B44.
This is a statutory interpretation.
Statutory interpretation question, but I'd also like to briefly touch on the question under Section 3 of the extremely hypothetical possibility that Trump might receive amnesty.
That's what this is going to.
By a supermajority. So starting with that supermajority point, it is extremely speculative that Trump would receive amnesty from 2/3 of both houses of Congress. He hasn't even asked for amnesty to this date. And this court has said that it does not decide questions that are purely hypothetical. He's disqualified unless and until 2/3 of Congress, both houses, grant him amnesty. And then turning back to the state question in terms of the timing, there are other scenarios where a candidate could become eligible later, but is not eligible now. The example, for example, of somebody who has a conviction, the filing officer is directed to remove them from the ballot, notwithstanding the possibility that they could get a pardon by election day or even by the date that they'd have to take office.